also then talk about solutions for sales tax compliance. So if you have issues and you're not sure exactly what to do, we'll discuss them as well. Okay. Okay, let me, my screen is now frozen. I don't know why. Okay, that may happen periodically. Just a way of background, I started my career at Coopers & Lybrand, dating myself, and I did state and local consulting as well as corporate reorganizations, mergers and acquisitions work. Then I was managing director at Telecom for many years, and then I was managing partner of a New York City CPA firm until I hung my own shingle. Now it's coming on 9 years this July. Okay, I have more than 25 years in tax and corporate law, and the reason why I've gotten involved was I've been working with some very large moving and storage companies here. Got an introduction to Bill, I guess, about 5 years ago, so Bill, maybe 4?
Yeah, 2014, I think.
2014, right? 6 years ago, I guess. And then I spoke at one of your fine conferences. I think it was up at West Point.
Yep,
and
right.
Periodically, Bill and I have spoken here and there. We got in contact with each other. And I'm involved in a bunch of audits and protracted litigation, specifically in sales taxes for moving and storage companies right here in New York. Okay. So first we'll go through some basics. Statutes and cases versus departmental guidance, their specific weight. Emphasize that sales tax is a trust fund tax, meaning there's personal liability. Usually sales tax is a destination tax. We'll talk about that, but maybe not for moving companies. Collection issues versus personal liability, bundling issues, and line item invoicing. Okay? So for our purposes, at the state taxation level, only statutes and court cases have any real legal weight. That's arguably different at the federal level. I do a lot of federal work as well. And the IRS, all of that guidance doesn't have equal weight, but it has a lot of weight. Really in New York, statutes and court cases are the only things that really matter. The Division of Taxation and the audit group will tell you differently, but at the end of the day, that's not true. Really, the only things that matter are statutes and court cases. Generally, sales of tangible personal property is subject to sales tax, if you don't know that. And then only specific services are subject to sales tax in New York. And the old rule of thumb used to be, even before I started my career, was no services were subject to sales tax. That's obviously changed significantly. And your specific industry now has become one that's looked at and has been cut and sliced and diced with regards to what services are taxable and what services are not. And as I say on the bottom, the next level of precedential value or regulations which interpret statute. Okay? All right, once again, this thing has frozen. Okay, this is going to be, keep going. Okay. So New York piles on all types of guidance. New York likes to issue all different types of guidance on what they think is taxable. And by the way, they draft it. So there's no legislation that goes through and two houses and the governor signs it. There's no trial or no courts that hear it. They just issue guidance all the time. This guidance is not law and it has no legal weight, although the Division of Taxation will tell you otherwise. Unfortunately, your industry was specifically targeted back in March 18th, 2011 by the issuance of two tax bulletins, 340 and 341. Apologize, I'm in my office. My phone may ring on occasion. So they issued these guidance to really specifically talk to your industry. And as Bill knows, we've spoken about these two releases that initially New York came to the Movers and Warehouses Association. Bill, correct me if I'm wrong, kind of with their thoughts, and then they never circled back, and then they just came up with their own conclusions. Right. And that's caused the problem with your industry, is this guidance is set out there like an albatross, and Bill's group never got to close the loop and really offered their final approval, even though New York says they did, but Bill is the one who was running at the group. He's like, that never happened. And this has been the thorn in the side for your industry. These two releases, TBST 340 and 341, have been sitting out there. Again, they have no real weight, but New York walks into audits and says that it does have weight. And that's why I've gotten involved in your industry so heavily with these two releases. And then they updated in February 2015. Okay? And like I said, these releases directly address your industry specifically. Okay? Now, these releases, basically, they alter the way many services are taxed in your business. They're not statutory, although New York treats them that way. and we'll get more into them in a bit. Now, what's important about sales tax is that it's a trust fund tax. And for those, I guess there's 39 people on here. For those of you who don't know, if you're the owner of your business, you're deemed what's called the responsible person. You could also be a CFO or someone making management decisions. If you sign off on certain paperwork, even if you're not the owner of the business, it says you're a responsible person, you now become personally responsible for sales taxes. Why? Because you're collecting money from your customers. Just like if you walk into a bodega here in the city and collect sales tax, you now have to remit that to the government. So this changes the game versus corporate income tax. So taxes are held in trust for the government. They have to be remitted. New York is very, very serious about collection of non-remittance. Collection of non-remittance is a felony, and it's a jailable offense. So it has to be treated very, very severely, okay? You as a responsible person are personally liable for this tax. If you go through an audit, they will most likely at the end of the audit issue a liability against your company and against you personally as the owner or responsible person for the company. Now, there's this concept of what's called destination tax. Under New York statutory law and regulations, New York is a statutory tax. That means if someone is shipping something to here in New York, let's say with Amazon, okay, basically you ship something out of state, it gets sent to you in New York, you have to pay New York sales tax. Okay, the final destination of the goods has always been that way in New York, and most states have a destination tax. Your industry, they've taken a little bit of a different nuanced approach to it for some reason. I think because it's just more palatable to them to get taxes. So basically the regulation in New York says, except to specifically provide otherwise, sales tax is a destination tax. The point of delivery, a point at which possession is transferred by the vendor to the purchaser or the purchaser's designee, controls both the tax and incidence of the tax rate. This also matters because in New York, there are state taxes and there are county taxes on top of that. New York has God knows how many different sales tax rates, even though you only file one sales tax form. So if you ship it from one part of New York to another part of New York, the question would become which sales tax is applicable. In your industry, it gets very confusing, especially because of when you take things into possession, when you're moving things, okay? So basically, New York is saying when you pick up the goods and you move them into your own storage facility, then New York is going to treat basically you taking possession as the destination point, okay? And in my mind, that becomes an origination tax. Because if you pick something up here in Manhattan and then you deliver it to your moving facility in New Jersey, the destination is really New Jersey. But New York says, we're going to treat it as the moment you pick it up here in the city. And this becomes a very big issue, which we're going to delve into later, which is one of the things that has been basically causing a problem for your industry for a while now, basically since 2011, is when you pick things up and you move them into storage, is there really sales tax on that? And how are we going forward from there? And a lot of this discussion is about that. So just know now New York has decided as a result of this release, TBS T340, that when you pick something up in New York City or Suffolk County, the minute it hits your moving van's hands, you now have taken possession. And that's where the tax has to be calculated, not where you're shipping it to storage. So if you have a storage facility, let's say in Buffalo, which one of my clients does, and he picks up here in the city, the tax has to be calculated here in New York City, not in Buffalo. Now, the real craziness gets involved, and we're going to get into this a lot more, is what if you're shipping it to New Jersey or Maryland or Connecticut? Is there sales tax there or not? And we're going to get into that a lot more. In my opinion, this approach, this origination tax, violates the Commerce Clause when you have out-of-state storage facilities. And again, we'll have questions and answers afterwards, and I'll cover all the bases on this. I know it sounds a little confusing. I'm going to round it out. And then afterwards, everyone can ask me questions as if I was actually in the room, which would be nice, wouldn't it? I look forward to those days. Okay. We'll go back to personal liability, not personality, I apologize. Now, keep in mind that even if sales tax are not collected by you, you as the responsible person remain personally liability for the tax. New York law is unique. It says that every person required to collect any tax imposed by the article shall be personally liable. In other words, if you're required to collect it, even if you don't collect it, you're personally liable. So that means if you undergo an audit and the audit comes back where the company owes $100,000 of taxes you should have collected for reasons of carting it in and out of storage, or you missed installation charges, or you missed properly, thought something was a capital improvement when it wasn't. The state will say, well, you should have been charging your customers that $100,000. Not only you, John Sullivan, moving company responsible, you also, John Sullivan, are personally responsible. This comes into play if you have a lot of money owed and if you can't afford it. Because if you don't pay this liability right away, you have to get into an installment plan or seek an offer and compromise. The state may issue a lien against you, against your company, and more importantly, against you personally. And we'll touch more on this in a bit. But these are important things. And a lot of times when I tell people this in the moving and storage industry or other industries, I work with IT and telecom a lot, event planners as well, highly sales tax, heavily taxed industries. People are always shocked at me that, wait, I have this personal liability? Yep. I never collected the tax. Yep. Even if you don't collect the tax, you have that personal liability as well. Okay. So that means, again, the audit occurs, state assesses a tax against you and against your company. Now, just so you know, this was always the law, but it was never put into practice until after the 2008 financial crisis. Everyone remembers that, which seems like 20 years ago. When these companies went bankrupt, a lot of these companies had sales tax on assessments. And the state usually only personally put the assessment against you as the responsible person if your company was in trouble and they knew. But if your company was viable, they never touched it. Or if you were teetering, you could always talk them out of it because no one wants that personal liability assessment. Well, after the 2008 financial crisis, so many companies went out of business, the state lost hundreds of millions of dollars in personal assessments. And they couldn't get them assessed after these companies went under because everyone was scrambling to raise revenue. So when I talked to Albany, when they started issuing these things around 2010, when they started this, they said this was directly as a result of the financial crisis. And I actually have clients all the time that are put in this position that are very upset about it. Viable companies, they go right after the owners right away, and then everyone owes the money. It's very frustrating. I don't think it's fair, but it is true. Now we're going to change gears a little bit, and we're going to talk about bundling. I don't know if everybody knows what bundling is. A lot of people probably do, but maybe a lot of people still don't. So basically, under the general tenets of sales tax law, if you bundle taxable and exempt or non-taxable services, the whole charge will be subject to New York sales tax. New York has taken this approach for decades, so has many other states. So if you, let's say, take a moving charge and you take an installation charge, because installation is subject to sales tax in New York, and you just put it as moving and installation, but in your mind, it's really mostly moving, but you put moving and installation all in one line item and you charge $10,000 and don't charge sales tax, New York will argue that actually the whole charge is sales tax. This has always been the case for decades, but still people, I'm shocked when I speak to new companies, moving companies, IT firms, other entities, I'm shocked they still bundle things together. That's why we're going to get into line item invoicing in a second. But always know that your words matter and you want to separate things out to avoid this exact problem. Okay? This is line iteming. Therefore, it's highly recommended you line item out your products and services. Because your industry is so nuanced, which we're going to get into more later, we're just kind of covering sales tax 101. The more detailed the invoice, the more control you have over the conversation in a review and audit by New York State. And the reason why we're having this discussion right now is your industry, if those on the call don't know, is highly audited because it's so nuanced. The states come after your companies for whatever reasons. I'll bite my tongue on why I think they do it, and Bill knows my feelings on why. But they are coming after you. I represent currently about 8 moving companies. 2 years ago, I was working with about 14. So right now, you guys are highly audited. So you've got to be very, very careful. So you have to be very specific on your invoices, line item them out. That way you control the conversation. Words matter in these things. In a recent audit, my client's billing department cut and pasted a new invoice service description from a prior invoice and ended up misstating the services being performed. The invoice should have been really non-taxable, but the auditor only cared about what was on the description on the new invoice. No matter what we did, we produced other documentation, went all the way up to the supervisor. It's like, well, this is what the invoice says, we don't care. So you really have to be careful with your invoices. The reason I bring this up is if you have large invoices going out the door with complicated transactions, moving storage, installation, packing materials, crating, things like that, you want to line item everything out specifically So you don't have an auditor come in and put a catch-all on you or reverse bundle, as I say, and say, you know what? We think you're all you're just listing it out the way you want. This isn't actually really the charges, so we're going to make it all taxable. Be very specific on what you're doing, where you're doing it, and that way you can have an argument with the state. And even if you don't win on the audit, at least when you go to the appellate group, BCMS or things like that, you can have an informed conversation where you have paperwork that can prove, hey, here's what we really did. Some was taxable and some's not taxable. Because right now, as you can imagine, in a pandemic, while we're sitting here on this ridiculous Zoom call, the state has no money. We all know this. We're all watching the news. No state has money. So my feeling is what's going to happen after this pandemic is over, the audit sword of Damocles is going to drop on industries all over New York State. This is what they did after the financial crisis. Guys like me were busy when I was at my old firm, busy like hell, because everyone was getting audited because the state had no money. This is exactly what I think is going to happen again. So right now, you want to make sure you're doing the right thing to protect your business, because otherwise things can get bad in an audit. We'll continue on line item and then move on. Again, words matter. Again, list out your labor charges clearly. I had this recently in an audit, ongoing right now. Packing on site at a client could be treated as part of the move and should not be subject to tax, while unpacking and packing at a storage facility is taxable since it's considered part of storage services. One of my clients didn't put that out clearly, and they put labor packing and unpacking, and the state didn't like it. They kept arguing it was at the storage facility. And right now, that's a major point where we're arguing it was labor packing and unpacking at a household. And we're going through this argument right now, and I'm speaking to the first supervisor, producing documents trying to prove, and this is real money. One of my clients does high net worth art right here in the city and sculpture. And they're working a lot in this industry, and right now we're having a few issues with that. These are considerable dollars. This is not a $100 charge. This is tens of thousands of dollars over numerous invoices. And this will have a material reflection on what could be owed in sales tax audits, because as you know, when you do an audit, they look at maybe 1 quarter, and they extrapolate it over, let's say, 3, sometimes 4 years. So if you get that 1 quarter and you have an assessment for, let's say, they say $10,000 of taxes owed, you multiply that by 12, you can do the math. Now you're looking at $120,000. So you really have to be careful. Small mistakes can turn into large assessments. Okay. I think this is the end of the line item. So again, it's highly essential. Also, keep your contracts you have with your customers, especially the customers that you're high, your high value customers. I've done, a lot of my clients have done work for large companies in the Northeast, as you can imagine. And right now we're having issues. Another one of my moving clients, we're actually going through the contracts. They worked with a large cable company around here, and we're going through those contracts. And without them, the state was going to make things much worse for my client. But keeping those contracts, spelling out exactly what you're doing can be very, very helpful if you need support, if you didn't properly line item out your invoice, or if there's discrepancies on what you think should have been taxable on the invoice. Sometimes the contract can be very helpful. Okay, now we'll go into sales tax and specific moving and warehousing services. Okay. So general laws on moving and storage. As we all know, in general, moving services are not taxable. This is because the service is not delineated in the sales tax law. Good. Self-storage, not subject to sales tax, nor are cartage services to and from self-storage. Just so you know, Bill and I have talked about this. One of the reasons that happened was the self-storage industry lobbied Albany, right, Bill, to basically say, when you guys started talking and they came to the moving industry, the self-storage people said, you know what, we don't want this to be taxable. So they lobbied it, and they said, basically, we want to be treated like you're renting space from us, almost like renting an apartment. So now self-storage not taxable, nor is cartage to and from the self-storage facility, because the self-storage is not taxable. Permanent storage, which is what a lot of people on this call work in, permanent storage services are taxable, specifically listed in the law. Okay, and this service is delineated in the tax law. And unfortunately, that's where the problem started with TBS ST 340 and 341, was using storage as the bedrock for now taxing cartage to and from storage. Generally, it was not taxed, but then that changed in March 18th of 2011 when they introduced this TBST 340, and they said, know what? When you pick something up and your company is both the mover and the storage facility, we're going to treat the minute it hits your trucks. That's when the storage starts, and we're going to treat that cartage into storage as now storage itself. Not moving, even if you line item it out, separate invoice it, or anything else like the state's like, nope. If you're a moving company, owns the moving facility and the storage facility, we're going to treat it all as one transaction. And the true object of that transaction is to store it. We're going to treat the whole thing as storage. And that's a big thing. Okay? Now, in general, all services associated with moving services are considered incidental to the move and are not subject to sales tax. This includes, as I spoke about before, packing, unpacking, loading, unloading goods, disassembly, dismantling. However, please note, installation and assembly may be and most likely will be deemed taxable. So, if you're moving someone into their new apartment or new office right now, which I'm assuming you guys have been quite busy during the pandemic, basically, and you go in and you're unpacking and dismantling, and you have guys who are doing that because that work probably is as complicated as the guy coming in and maybe setting up computer monitors or putting together cubicles. That's called installation and assembly. That's taxable, but meanwhile, the packing and unpacking isn't, oddly enough, and that's how nuanced the law gets. So if you're line-ironing out things, packing and packing and unpacking, that's one thing. You can argue that's not taxable. However, installation and assembly will most likely be taxable. And every time I've gone through an audit, basically I've been working with your industry since 2009, I believe. If I'm getting my numbers right, I've seen them go after that. So that one is no longer will, it's definitely will. They definitely will. Again, unpacking and removal of packing materials, generally not going to be subject to sales tax. Okay. Again, installation and assembly may be different. If the separately charged assembly or installation services that do not become an integral part of the real property of the customer's destination, then the service is subject to sales tax. However, if you can argue what you're doing is part of real property, integral part of real property, then they could deem it, you can deem it a capital improvement. Okay? That's different. So basically, assembly or installation where you're just putting together a cubicle or something like that, computer monitors or setting things up in general, anything like that is generally not going to be part of the real property. However, if you're coming in and arguably installing walls that cannot be readily uninstalled, or you're putting in, let's say, wiring that is very difficult to get out, or, I don't know, glass partitions that are not readily removable and will cause damage to the real estate in the building if you do, after you put it in, and that's a capital improvement. And under New York law, capital improvement services, installation, if you will, are not subject to sales tax. Other installation is, and this is important because capital improvements are very, very often abused. The capital improvement certificate is one of the most abused certificates in all of sales tax law. And just because a customer hands you a capital improvement certificate doesn't mean it's a capital improvement. You are required under law to understand the service you are performing. So basically, if you're invoicing for installing monitors, right? And I had this issue with a client of mine in Pennsylvania, and it was a large company, really large. I won't say their name because there's only a few that do what they do in Pennsylvania. And they handed over these capital improvement certificates. We're like, there's no way this is what you're doing. There's no way it's capital improvements. Because basically we're putting together cubicles and computer monitors and things like that. And we had a long discussion with their general counsel. And we said, we're not doing this. We're not accepting your capital improvement certificate. At the end of the day, we would hire up to that, was the CFO of the company. And he's like, you're right. It's not capital improvement. We'll allow you, the moving company, to charge us sales tax. Otherwise, my client could have been on the hook for hundreds of thousands of dollars. And I'm not joking, hundreds of thousands of dollars of sales tax in the state of Pennsylvania. So you have to be very, very careful. When these capital improvement certificates hand it to you, say thank you, understand what you're doing, and then talk to your counsel to push back if you're not comfortable. And you have to do it then. After the fact, it's not going to work. Once you send the invoice and everything else, the horse is out of the barn. I've done so many of these. You got to cut it right then when they hand it to you, research it, make sure you're comfortable. Because at the end of the day, You're going to have a hard time going back to your client to get that money if you get caught on an audit. It can happen, sure you could, but most of the time I find that these big companies are like, you want to do business with us? You'll pay the tax. Too bad, you didn't do it up front. And that's Form ST-124. So be very, very careful with that form. Don't accept it. My joke is they hand those things out like Pez candy when Pez candy used to. Okay? Now we're going to get into the bugaboo that's been haunting your industry since 2011, cartage in and cartage out. So basically what this release said is storage services are considered to be delivered at the location when the storage service provider takes possession of the property to be stored without regard to the location of the storage facility. Therefore, where a storage service provider takes possession of property in New York, that sale is subject to New York state and local sales tax. So basically you come in and you say, I'm going to take stuff from Sullivan Associates here in New York City, and I'm going to store it in New Jersey. I charge one invoice one for my movers to pick it up, pack up all his stuff, and then move it to New Jersey. And in New Jersey, I charge storage services for month one in New Jersey. Normally, the way it's always been done, Bill, correct if I'm wrong, in your industry, my clients, what they did is they issue invoice one, no sales tax moving, use your moving labor guys, union or non-union, then move it to the storage facility and then charge the tax there. New York, as a result of this writing, not sales tax, not law, just some release they put out there. I always joke some guy was hung over one day and wrote this. They said, it's all one transaction and we're going to treat the whole thing as moving, okay? And New York argues this, that it's all one transaction and basically it's all the true object of storage. And it gets weirder. It also says charges for transporting property to storage and returning it from storage are included in the tax or receipt for overall storage, okay? And that happens if you're the moving company and you also own the storage facility. Now, the nuance in the law is if you're the moving company and you move it to someone else's storage facility, then no, that doesn't work because it's not all one transaction. But here, what they're talking about, as you can see, is cartage in to your facility and cartage back out. So they're saying if you move it someplace for 5 years, right, you charge storage the minute it hits trucks, then storage in month one, and then arguably when you move it back out, let's say 5 years later, then now you have to charge storage even though you're shipping it back out of storage, which in my mind, using English, is moving. That's how bizarre it gets. But trust me, it gets weirder than that. Okay? So now, like I said, if you move it, but you don't own the storage facility, then you don't have to worry about that. Just so you know, if it's going to outside of New York, now you violated the U.S. Constitution, the Commerce Clause, because it's discriminatory, and it's a big problem for those that have movers that work here in New York and storage facilities in New Jersey. Okay? So basically, what does this mean? You charge $100 for the move for the goods to the storage facility. You issue a separate invoice, then charge $200 to store the goods. New York says both the $100 invoice and the $200 invoice are subject to sales tax as taxable storage. The reason is they say the true object, the primary purpose of the move is storage, and therefore it's all storage services. This is ridiculous. You should be able to invoice the way you want. Still capitalist country as far as I know. Invoice one, you're using your 2 labor guys that only do moving, and then you have labor guys in New Jersey or where else in Connecticut, and they are the labor guys who do the storage. Different skill sets, they may be unionized, not unionized, who knows, but you should be able to invoice the way you want. New York is saying, no, we're telling you, we're going to all put it together. And I've had God knows how many arguments about this with the state. So the ramifications of this, obviously, are quite problematic since labor is different from moving and storage often, and it's a patently unfair problem. Bundling versus line item goes out the window. Separate invoicing goes out the window. Destination tax goes out the window. Ability to invoice as you see fit as a business person goes out the window. And lastly, the Commerce Clause. And let's not minimize that invoicing issue. Why should the state be telling you what's taxable when you're properly invoicing how you're running your business? And that's where I have a problem. Also, they just throw out this concept that destination tax applies for everybody except for your industry. They're singling out your industry and of all the other industries in New York, and they say in your industry, you're not a destination tax, you're an origination tax. And this is them going specifically at your business group. I don't know why they've done it. Again, I have my reasons why I think. Bill knows why, but I won't get into it. But it's patently unfair and discriminatory. Okay? So again, discrimination in the workplace, right? And also, why should you be penalized to charge New York sales tax while movers who don't own storage facilities don't have that same problem? Okay? Also, if you've got the storage facility outside of New York, you've got a problem because now you might have to charge tax twice. But here's where it gets worse. Intervening month storage. So now, as mind-bending as all this is, if you care about your business and the sales tax, now New York is saying something even crazy. They're saying you move the goods in year one from a New York client and then store the goods for 5 years in New Jersey. And then you move it back to your client's site. New York says cartage in, taxable, and all 5 years it's stored in New Jersey because your client was a New York client that you now have to charge New York sales tax in New Jersey. Now, obviously, this is illegal. It's unconstitutional. And the problem is it's also double taxation. So the whole thing, from the minute you pick it up to the minute you bring it back 5 years later, the whole time, they're saying New York should be taxing this. I had this issue with one of my clients. I still have the issue with one of my clients. And I got that partially removed. Okay? It's a huge, huge issue. And we're going to get to what's going on with the issue now because there was a court case. Okay? It's ridiculous. It's unconstitutional. How can something be sitting in month 2 in, let's say, Secaucus, New Jersey, and somehow still be taxable in New York when all the transaction is happening in New Jersey? You're in a protected facility in New Jersey. You pay rent in that facility in New Jersey. You have security in that facility, HVAC, everything else like that. And you're issuing monthly invoices to your client who happens to be in New York, but the transaction's happening in New Jersey. By the way, sales tax is also a transactional tax, right? Every transaction is looked at uniquely. It's not looked at annually like income tax. Every transaction is treated as its own story. So this goes against all aspects of sales tax law. And again, being specifically targeted to your business. It's ridiculous, it's illegal, it's unconstitutional, it's unfathomable, it's unethical, it's unbelievable to me. And when this was first raised to me 4 or 5 years ago, I couldn't believe they were trying to do it. We got rid of it. They came back for a second audit with my client, and then they reinstituted it. And that's where I am with one of my clients. Again, we talk about cartage out. How can you have this issue when you're moving it back out of storage? Because you're not storing it anymore, you're carting it out. So that's moving, in my opinion. Again, if there's an unrelated third-party mover, that changes the equation. The discriminatory inconsistencies in all of this are truly astounding. They really are. The hypocrisy and the BS, and when you talk to these people up in Albany, it's crazy. But then some sanity returned. This summer, in August of 2020, as I was talking to the government about my client, there was another case going on, Vital Records. A summary judgment was issued by the New York trial court overruling the state's position that the intervening month storage and an out-of-state facility are not subject to New York sales tax. This is a huge thing because basically New York was taking this position, not written anywhere, not even written in TBS ST 340 or 341. They just made it up. Now, what the state says, and it's not all good news, but it's mostly good news. What New York said is, unfortunately, cartage into storage remains taxable. I do not agree with that. It's BS. We think it should be line itemed and separated, invoiced out, however you do it. But New York said, no, we're going to respect the true object test. Also, oddly, they say that first month of storage should be subject to New York sales tax. I don't agree with that either. So again, you pick it up here in New York from my firm, you move it to your facility in New Jersey, they're going to say, the move, the cartage, subject to sales tax. Oddly, month 1 is also subject to sales tax because it's a continuation of a New York transaction. Don't ask me what that means. It's ridiculous because it's in a New Jersey facility. But what they did say, though, was after that, that's the end of it. But no New York sales tax is owed for any other months of storage held out of state, which in this case was New Jersey. So month 2 forward. I have clients that have worked for law firms. They have stuff in storage for 8 years. They were worried that in the last 3 years, not the 8 because the statute of close, for the last 3 years, they could have this intervening month storage problem. They were looking at an assessment of, 1.4 million, we estimated, of sales tax they hadn't charged to any of their New York clients. This case reversed that. Now, what's unique here, oddly, is they did not address cartage out. I don't know why they didn't address it. My feeling is because they cleave the transactional nexus string or tail, if you will, by month 2. My feeling is when you cart it back out of storage, because they're considering it New Jersey storage the whole time if it's out of state, then the cartage back out will not be considered basically a New York storage transaction. It would be considered either a New Jersey or a New York moving transaction, which would not be subject to sales tax. Now, here's the interesting thing about this case. Beyond all this, this company, Vital Records, went through exactly what my client is going through right now. They went through one audit where the state said cartage in, cartage out, intervening months. They cut a deal with the state, and the state said, you know what, we won't go after the intervening months. We won't go after cartage out, and we'll only go after some of the cartage in. And they cut a deal. This is in the decision. But right after that audit closed, they came back, and they said, we want cartage in, now we want intervening months. We just cut a deal for that one, and we want cartage out. So this client, that's not my client, but Vital Records said, you know what, we're not even doing the audit. We're going to make an Article 78 motion, and we're going to go right to court. And they didn't even go through the audit. They made a judge tell the state, this is, with all due respect, BS. That, oddly, is what we were going to do with my client. We were doing the exact thing as this was coming out, and we read about it. That is exactly where we were going. Because my client's like, we're not doing another audit, Jack. We like you, but we're not going to pay you, for a year protecting us from this audit. We want to take a litigation approach to cut this short. So basically, we did that, and we were going after that, and then Vital Records had done the same thing, and they're like, no. So now there's a trial court decision in New York that says this intervening months is not taxable. Again, cartage out, it doesn't address, but my feeling is that should cleave it. Now, if you've been charging your clients the cartage out, for those that have been doing it, some may not have been. If you've been charging it, I suggest you continue doing it if you haven't lost any clients. If you haven't, my feeling is I don't think you should start unless you're really concerned. Because I do think this logic follows that once it's cleaved off, you shouldn't have to charge cartage back out. If you're worried about it and you know you won't lose clients, then this is the first time you're hearing about it, you might want to start charging the tax. Now, to go back, if you've never heard of any of this, cartage in, cartage out is taxable, then cartage in, you probably want to start charging that tax because of that continuation of storage. And the state now has put it in a court case, even though I don't agree with it. It now is in a court case saying, even though it's a low-level court case, saying cartage in is taxable. And the state could show up at someone's door and say, all right, fine, we're not going to hit you for intervening months. They may not touch cartage out. And I've cut deals on cartage out. But cartage in, they could produce Vital Records and say, you know what? Even though there wasn't a statute, we have a court case, a decision by a judge. Even though it was a low-level court, it wasn't a real trial court. There were no jurors. It was a summary judgment in front of a judge. And a judge wrote the opinion. So it has some weight. And we'll go into later what to do if you have outstanding liabilities that you have and you haven't handled with the state. But just know this is a big, big issue. Bill and I have discussed this issue. That's why I reached out to Bill, was about this court case. And it was a huge thing. It didn't get much publicity. It was very quietly handled, which is the way the state wanted it. Obviously, we're in a pandemic. So no one really knew this went out. And it didn't get a lot of, like I said, a lot of reaction in the industry. Okay? So we're going to continue from there. Change it up a little bit. Just know on-site storage labor is taxable. State of New York comes after you very hard. Anything that's done on site at your storage facility, you're moving large things around, you charge your client because they want it in a better part of the storage facility, or you move it somewhere else because they asked for it, or you're prepping it to be moved back to New York or wherever else, and you charge them for that labor. That labor in that storage facility is taxable. I have a client right now who charges all the time. They went through an audit. I told them to start charging. They didn't do it. State came back second time around, and we have a big assessment that we're going to have to beat back because they did not charge tax because their clients didn't want to pay it. And I understand how competitive your industry is, but you have to weigh that out. Do I want to charge the tax or possibly lose the client? My feeling was they already had the client stuff in storage. They should have really addressed it when I told them they didn't. But just so you know, pull charges, warehouse, labor, preparation for move out of storage, unpacking, all of the storage facility is storage. Okay? So now, here's an interesting thing that changed on the most recent result, the most recent, if someone's talking, I can hear them, you can mute. Storage and transit changed. It used to be more or less 30 days or under with storage and transit. Now New York gave a more favorable interpretation of law, basically saying that will allow storage and transit not to be taxable as long as you meet our criteria. Okay? So in their instance, the mover is providing customer a transportation service. That is, the mover provides the customer with a bill of lading specifying a destination address different from the address where the mover picks up the property removed, different from the location where the mover would provide storage. Okay, and you have to meet all these conditions to get the storage and transit exemption. So the old rules was generally 30 days. Now, if it sat there for 90 days, you were usually, SOL. You didn't have luck there. But now New York has given really the movers more flexibility, okay? And basically, they're also saying that you as the mover have to be responsible during this period of storage and transit. And if you can show that, then arguably you won't have to charge sales tax. Okay? The requirements also, the mover remains responsible during the storage and transit period, and any charge for storage and transit made or identified prior to the commencement of the transportation service does not exceed the amount of the charge for the transportation. And the most important thing, keep records of this. So if it comes up on audit, which I've had recently come up on audit, you can show it clearly says this is storage and transit. Mr. Sullivan's getting his office redone for 4 months. We're holding all his files and everything else in our storage facility, but it is not permanent storage. Therefore, there is no tax. Because if you don't have all that, the state will come in and they'll say, you know what? We're going to treat it as permanent storage, not storage and transit. We're not going to just take your word for it. The state's not taking your word for these things anymore. These are very acrimonious audits. They're very aggressive. They're very picky audits. Again, the reason for that is a mistake in one quarter gets extrapolated against to basically 12 quarters, possibly 16 quarters if it's 4 years. So they want to find as much as they can in one quarter. And these audits are not nice. They become unfriendly. So you have to really cross your T's and dot your I's. Okay? Am I doing okay on time, Bill? Okay, great. One last thing, and then we'll go into some cures. Trash removal is taxable in New York. I'm sure most people know this, but I still see it in audit. So if during the move you take your customer's refuse and throw it out, that's subject to sales tax. It's irrelevant where you take it to. You pick it up in New York, it's New York waste removal. I have a client, same client with the New Jersey facility in Secaucus. He gets rid of it in New Jersey. They don't care. It's that concept of origination tax comes back. And they actually refer back to that TBST 340 and 341, say, no, it's where you pick it up. You now are a waste removal company, and we're going to tax you. Okay? One or two last things. Knockdowns, on-site knockdowns. That's deemed part of the move, and without removal and reinstallation, it should be exempt from New York sales tax. On-site, knockdown and reinstall a different lockdown. Knockdown, if separately stated, should remain exempt. However, reinstall, if not deemed a capital improvement, will be subject to sales tax, assembly, or installation. Reinstall that is deemed a capital improvement will be exempt. So keep that in mind. A lot of times my clients kind of put it all in one line item, knockdown and reinstall. I see it all the time. And they say non-taxable because it's part of the move. The state says no, knockdown and reinstall, we're treating that as a reinstall. At the new location, we're going to argue the whole thing is subject to sales tax. Now, a lot of times when you have this, if you can break down that line item and show the knockdown was $10 to do it and the reinstall was $20, you can prove all that, and you have a reasonable auditor, you should be able to get that change, but not always. Depends on the auditor. If anybody's gone through an audit, you know this. But if you can, line item it out. I have clients now that issue much longer invoices as a result of doing business with me or coming to me after an audit or during an audit, and they realize now, wow, you weren't just saying that. We really do have to line item this out. I don't think it's fair. I don't think it's right, but it is the state of your industry right now when you deal with New York when it comes to audits. Again, on-site knockdown, trash removal, same concept. Okay, but the trash removal is going to be taxable. Again, this is that true object test. Possibly sometimes the state will say you're knocking it down and you're throwing it out. The state could say in that instance, no, the true object is really trash removal. I've had this come up once. I advise some of my clients, if they think they know that they're knocking something down and they're going to throw it out, if you don't think you'll lose a customer or be at a competitive disadvantage, my feeling is because of this ridiculous true object test that you should charge sales tax on that, because the true object of what you're doing is trash removal. Even though we know knocking down is not trash removal, the state bends this true object test to what they want. And they say, you know what, no, that's the true object of what you're doing is trash removal. So be very careful. When in doubt, tax, as long as you don't think you'll lose a client. And if you have questions, reach out to someone, your CPA, someone you trust, an advisor like myself. Say, hey, I got this transaction, I'm not sure. And the reason why it becomes important is, again, one little tax issue can grow into a much larger tax issue over an audit period. Even though it seems small now, you have 10 or 15 of things within a 3-month period, extrapolated over 3 years, which you'll forget about 3 years from now, that can really bubble up into a lot of tax owed, which, by the way, will also have interest on it and possibly penalties if an audit were to ever ensue. Okay? Last thing, and then we'll move forward, packing materials, okay? Often confused. I have a client on Long Island that has real serious packing material issues, okay? Any sales of cartons, boxes, barrels, covers, crates, you name it, directly to the customer for use by the customer is or taxable if the customer takes possession of the material. So anything that you're doing in a carton that you buy and you leave there, and you have to charge sales tax to your customer for that, because they are retaining possession of that. Because arguably you've not paid sales tax to the person you bought it, your vendor, you're reselling it. What you can't do is not pay tax to your vendor and also not charge tax to your customer, because there, now what do you have? A non-taxable transaction. New York doesn't want things taxed twice, but it also doesn't want things taxed 0 times. So you have to be very careful with that. A lot of times what people do, because it's always the way they did it, and just because you used to do it that way doesn't make it right, is they would give the resale certificate, let's say to Staples for crates or cartons. I'm sorry, not crates. Let's say cartons or boxes, right? If you're a small moving company, you walk in, you hand Staples a resale certificate. And then you come in and do the moving with me, and you don't, but you leave everything. I retain all those boxes, but yet you don't charge me tax for that. A smart auditor will come in, look at all that, and say, wait a second. You used a resale certificate when you bought it from Staples because we have the receipt. And yet you didn't charge Sullivan and Associates tax when you left the cartons there, the boxes. Why didn't you do that? And then you get assessed taxes. Okay, this is a big deal. Happens a lot. It adds up very, very quickly. You have to be careful. You got to pay tax somewhere along that line. It's not a non-taxable transaction. Apologize for the double negative. Okay, packing materials that are resold to the customer and become property of the customer will not be subject to tax when purchased by the mover, provided the mover provides a resale certificate to the seller of these materials. Again, the mover must charge sales tax to its customer. Okay? And the alternative, if the mover pays tax for the moving materials it purchased and later resells them and collects sales tax and the materials become property of the customer, you could take a credit on your sales tax return because now that thing has been taxed twice. Proof of payment of sales tax to the vendor of the supply should be kept by the mover when you apply for that sales tax. Okay? Now, all items used by the mover while performing a move, tape, markers, etc., are not considered being resold and are deemed consumed by the mover, and sales tax must be paid to the vendor at the time of purchase by the mover. So again, if you went in and you bought from a vendor, anything like that, tape, marker, crates, cartons, whatever, and crates aren't a good example. I know it's nuanced. We're not going to touch that too much here. But things like that, if you buy it and you're going to use it and you're going to keep using it or retain it and you don't charge your customer, you've got to pay sales tax on it because you're consuming it to do your business. And that's just the cost of doing business, paying sales tax, just like if you were buying it in your personal life. So keep track of that stuff. A lot of times, again, I have people, they go in, they use the resale certificate, they buy all this stuff from their vendor. They don't charge anybody, yet they consume it, and sales tax is never paid. And this can add up very, very quickly. And what happens a lot of times for companies, and I know a lot of you people are family-owned businesses, your families have done things the same way for decades. Just because you've done it that way in the past doesn't mean you should keep doing it in the future. Because if something happens, you come in and you know, as you're hearing me talk in my annoying, raspy voice, that, wow, we have not been charging this tax. That's a problem for you. And we're going to talk about solutions in a minute. But just know, don't put your head in the sand on this. This is a big issue. I have clients that have huge problems with this that we're trying to solve right now. And this is a very common problem in the moving and storage industry, this exact issue, where no tax has been charged anywhere, nor tax has been collected. You got to solve these problems, because if you come in, it's huge. And again, interest adds up on the taxes that can owed, and sometimes they'll assess penalties as well. So, change gears for a second. Let's talk about solutions for sales tax non-compliance. Okay. So if you have collected sales tax and didn't remit, or you didn't collect the tax on a sale and should have, since you had a tax bill sale, what should you do? The first thing you don't do is you don't call the state. You don't change how you file your sales tax returns. You want to talk to an advisor about the best solution. And generally, what I recommend in 10 out of 10 times, if someone wants to cure the problem, and you may not. You may be like, you know what, Jack? Let them come and catch me. I get it. People do it all the time. I've talked to many people that Bill has referred me to in your group, and they're like, you know what? Let them find us. We realized Bill told us you had given a presentation. We realized we've got some problems, but we don't want to come forward to the state. We're going to owe them too much money. Then you can roll that dice if you want. If you don't want to roll the dice, and maybe you sleep all night, and if you don't sleep all night, then you could do a voluntary disclosure agreement. Okay? New York allows you to come forward voluntarily. Unfortunately, it's not anonymously anymore. It used to be. And divulge your exposure. Most states are anonymous. Even New York City, which doesn't have its own sales tax per se. New York City's anonymous. New York's not. So you have to come forward to them and tell them who you are. But the good thing about it, it waives all civil and sometimes collection of and criminal penalties. As I said before, if you're collecting and not remitting, that's criminal in nature. So a VDA, as long as you've never been contacted by the state previously, a voluntary disclosure allows you to have waiver of all civil and criminal penalties. That's a big thing. Okay? The other thing that's very important is that it allows for a limited look-back period. So let's say you've had this exposure for 10 years in your business. You've been filing sales tax returns, and you know packing is a problem for you. And let's say you know cartage is a problem for you, without a doubt, dating back 10 years. You do a VDA, you come forward, guess what? As long as you've been generally filing everything else like that, you've got 3-year look-back period. You don't have to go back 10 years. 3 years only, which is great. So then that way you're basically saying, okay, 3 years, not 6, not 10. Now, if you've been collecting and non-remitting the tax for sales tax, then you have 6 years. So 3 years, non-collection or non-compliance issues or things like that, 3 years. Otherwise, it's 6. Unfortunately, under the new regime in New York, and I say new, it's been this way for 10 years, prospective treatment is not a possibility. That means only go-forward basis. Those days, when I first came out of law school, we used to get those deals in New Jersey and New York, and sometimes in Pennsylvania for sales tax. Those days are long gone. So you can't call your advisor and say, I only want to pay the sales tax prospectively. They don't cut those deals anymore. Those deals are gone. So basically, you do a VDA. You want to contact an advisor to shepherd you through the process. It is done online. I generally call the state first to kind of discuss the deal before I do it. I know some of the folks up there. So I don't suggest going through the process on your own. I do suggest you speak to someone to understand the nuances of the process. Okay. Now, if you owe more than you can pay all at once, you can seek an installment plan. That can happen if you do a VDA or if you have the completion of an audit. Those plans could go 5 to 6 years. One thing that's important is liens may be placed on your business and possibly you as the business owner. As I said before, if a sizable assessment hits your business, they're most likely going to also assess you personally. And if that dollar amount exceeds $25,000 to $50,000, most likely they will file a lien against you. A lien is something that protects the state's interest in case of the filing of your business or you personally in bankruptcy. Just like your mortgage, right, for your home, the lien holder on that loan is the bank. So if you stop paying, the bank come in, right, and foreclose on the home. That's because they sit first in line in bankruptcy proceedings. New York doesn't have that right if they don't file a lien. Everyone thinks the states have this right, or the federal government. They have to actively file a lien against you. And that's why this is done. People don't like it. You want to avoid it. But just know there are installment plans out there if you need them. Okay? And then in the last resort, if you owe too much money and you can't pay it, you can do something called an offer in compromise. You probably have heard these on the radio. The IRS does them, but New York State does them, as do many other jurisdictions. So basically, that may allow you to pay less than what is owed. Basically, generally, we'll all do so in the non-collection situations. That means in a collection situation, let's say you owe $50,000 to determine, right, in sales tax you collected. Generally, the state's like, we want all $50,000, we want the interest, and we may penalize you. You won't be able to cut a deal. However, in the audit, let's say you didn't know you had to collect that $50,000 because you didn't know this nuanced crating issue was going to be a sales tax matter, or you never charged cartage in or cartage out back before that court case, and you can't win on that. And you know that. You can file paperwork in the state of New York for sales tax to try and cut a deal to get you to pay less in sales tax. That's also true if you owe sales tax on expenses for which you never pay tax, or fixed assets, okay? Now, collection and non-remittance is different. New York is not as flexible with trust fund tax. Company and owner responsible persons have to have joint and several liability. They want the money from the company and you as well. And if you have this issue, let's say you solo own your company and you decide to file an offer in compromise, which is a lot of paperwork, a lot of discussions with the state, the company has to file it and you as the owner also have to file it. And that gives the state a roadmap to your financial life for you and your business. A lot of people are very uncomfortable with it, but it can also give you a haircut on what's owed. A lot of times what you're doing is you're getting interest removed and penalties removed. However, if you have a $100,000 assessment that dates back 5 years because the audit went on for a while, that interest and penalty could be another $50,000. So if you cut a deal with the state on an offer and compromise on a non-collection issue, right, and it was the assessment of penalty and interest $150,000, you get it down to, I don't know, $100,000. $50,000 of savings is worth going through the process. So it's something that it's a place of last resort. I do it all the time for people. I have a feeling I'm going to be doing a lot more of them. I did them a lot in 2020 because of the pandemic. I have a feeling I'll be doing a lot more in 2021. Okay, hold on. We're almost done. For those whose eyes are turning back in their head. Lastly, remember use tax. Use tax is the sister of sales tax and is due on any goods your business uses but didn't pay sales tax. So if you buy fixed assets from out of state, they ship it to you and you use it in your business, right? And you undergo an audit. Know that just because they didn't charge you sales tax doesn't mean you don't own it. You have to self-assess. Same thing with expenses. Let's say you use a small provider for all your office supplies located, I don't know, in Delaware or somewhere, and they ship everything to you. No tax is charged. And you're using it here in New York or New Jersey. You have to self-assess use tax on those expenses. When you go through a sales tax audit, they look at sales, they look at fixed assets and expenses. And in fixed assets and expenses, if they don't see these taxes paid to New York or self-assessed, they will charge you those taxes. Luckily, those are not responsible person trust fund taxes. Not as aggressive on the other matters. You can cut deals on OIC, offer in compromise with this, but just know this can add up. I have a client right now, we have huge expense issues because of what? Packing material problems, where no one paid tax. So now they're saying this is use tax, and it's a big, big problem. And I think that's it, Bill. Nope, you can open it up now.
Thanks, Jack. Yeah, I don't know, Jack, can you see the chat? I know there were a couple of questions during.
Let me see how this works.
Yeah, I think you covered a couple of them. There were just questions about storage and transit, and there was one question: is the warehouse labor?
Find it.
Yeah.
Hold on. More. Okay. Record, disable, no. Stop video security, new share. I'm not seeing them. If you want to read them to me, I apologize. I'm just not seeing them.
Yep. No, that's all right. I can do that. And there's only a couple I can see as of right now. But
Okay.
Is the warehouse labor in New Jersey chargeable to New York tax or New Jersey tax?
Under this court case ruling, I'm going to argue, obviously, New Jersey. Previously, I think the state would argue New York, which is comical, right? Because you've got a guy sitting in New Jersey doing all that work. But right now, basically, I'm going to take the position that is New Jersey labor. What I suggest is, if this is an ongoing audit issue, talk to your advisor. If it's an issue you're not sure about, again, speak to your advisor. If that's what's going on, I think you take the position that it's basically New Jersey. But if this is a large dollar amount and you have outstanding issues with this, you might want to have a problem. We might want to have a discussion with somebody to see if you can be aggressive as a result of the Vital Records case to try and get some type of resolution on the matter. But if you don't want to do any of that and you need a position to take right now, I would charge New Jersey and rely upon the Vital Records case. And right now, I know for a fact New York doesn't know what it's doing because my audit's on hold. One of my audits is on hold as a result of this, and they don't know what they're doing. They literally, we have, since Vital Records in August 2020, I get an email from the state every 2 months saying, we're still thinking about what they're doing. So they don't know if they're appealing the case or not. So my feeling is I would charge New York tax. Otherwise, New Jersey wants their piece too, right? And New York argues that the statutes are different, which is ridiculous because New York doesn't have a statute. It just has its interpretation. So New Jersey's saying, no, there should be New Jersey tax. And New York is saying, there's New York tax. And now you're charging what? 15, 16, 17%, whatever it is. So my feeling is I wouldn't want to go that way. Because of Vital Records, I feel at this time you should be charging New Jersey tax. But again, it's not straightforward, unfortunately.
Okay, a couple more came in, Jack. Someone wants to know the storage of files, and I guess just in general, non-household goods, is this taxable?
Yes, storage is storage.
Storage is storage, yeah.
Storage.
Storage of boats and cars. This person has an understanding that if you allow the owner to work on the boat or the car, you did not have to charge tax.
Well, I guess that really comes down to whether that's self-storage or not, right? And to me, I'd have to see the contract. But if you're allowing someone to come in, right? Because from what I understand, most of you permanent storage vendors, you bring it back out. You can't go into the storage facility and go get the stuff. So to me, that seems like a self-storage. If your contract doesn't say self-storage, you may have an argument on your hand with the state. To me, it seems like you have an argument there that could hold up. But I recommend that you, if you haven't done it already, that you tweak your contract to make it seem like it's more self-storage, because self-storage is clearly not taxable under New York law. That's what I recommend. Because you're going in and you're working, and arguably they're renting that space, and you're allowing to work in that space which they're renting, and that's what self-storage lobbyists argued for and got arguably in the law by not taxing it, right? It's not delineated in the law. So if you can, I suggest speak to your lawyer, but if, as long as your customers are comfortable, tweak your contract to say this is self-storage if you haven't done it already.
Okay. I've got another one, Jack. Someone wants to know how an installation that they did in New Jersey is taxed when their company is in New York. Do they set up tax payments to New Jersey?
It's a great question, and this is the problem. It shouldn't be a great question, right? You shouldn't have to have this mind-bending conversation on where to tax.
Right.
It's stupid. If the installation was done on site in New Jersey, the installation and everything was performed, that's New Jersey sales tax. I've not seen New York yet try and go quirky enough to say that a New Jersey installation for a company that may have an office in New York is somehow New York installation. And your question's not dumb. If this was 20 years ago, everyone would be like, it's crazy. Obviously, it's not crazy. But I think Vital Records now has stopped that train in its tracks. Because that is easy in the law. For anybody else on here as a lawyer, we use that as precedential value, right? We say, this court said X. We have to follow that law interpretation until otherwise overturned. So that's an easy analogy. Intervening month storage, no way. And that court case, which we didn't get to in depth because we'd all fall asleep, basically said you can't tax a transaction for labor happening in another jurisdiction. We're the U.S., right? That work's all being done in New Jersey. That installation work we're arguing and talking about right now is happening on site in a New Jersey facility, wherever it is, on site of the client. Therefore, New Jersey sales tax. Hope that's helpful.
That's all I have right now, Jack. I don't have any other ones coming in.
Great. If I can add one thing, Bill.
Yes, of course.
Off topic, I didn't cover it. Just know anyone who's got the PPP loans right now, I have a newsletter that goes out. They reopened it yesterday, but mostly for community lenders and things like that. And first draw folks should be coming online maybe today or tomorrow. The second draw technically opens up tomorrow, but a lot of banks, Chase is not going to get online. A lot of banks aren't going to be online. The big thing on the second draw is you're going to have to be able to show a reduction of 25% in any given quarter from 19 to 20. So if you got PPP already and you want to get a second draw, I highly suggest you get it, especially since now everything is tax-free. You get it forgiven, and the expenses paid with the PPP loan proceeds are now all tax deductible. So there's no reason not to go get it. So the PPP second draw opens tomorrow. If you're going for the first draw, go to your banks today because it opened yesterday. It may not be fully open yet unless you go to a community bank and some of the more underprivileged folks who didn't get the advantage of the PPP. That was specifically in the new law. But PPP is online again. And if not, it'll be online tomorrow for your second draw, folks. So I just wanted to put that out there because we have 40 people on here. And I'm assuming some people might have to utilize it. So I just wanted to put it out there.
Yep. Great. Thanks, Jack. Appreciate it. And again, everyone recorded this session. You don't have to ask me for it. I will email everyone that was on this call, including you, Jack, the copy of the recording. And with that, just like to thank you all for attending this morning. Jack, thanks so much for participating and being here and answering questions from our group. Very much appreciate it.
Great. Thanks so much, guys. Talk to you soon.
All right.
Bye now.
Thank you. Happy New Year, everybody.
Happy New Year. Bye.
Thanks.